It starts with paperwork, an unpaid invoice, a broken contract, a repossession order. But by the time a high court enforcement officer receives it, the case has moved far beyond negotiation. In 2025, enforcement still meets resistance at the door, and increasingly, resistance that hides in code and online accounts. They carry the authority of the courts, but step into confrontations that can turn hostile within moments, as officers themselves describe facing threats, intimidation, and aggression. In this film, we'll show how a court order becomes a knock on the door, how officers operate, and what new challenges define their work today. And at the center of it all, who exactly are these officials, and why do they stand apart from everyone else in Britain's legal system? Who are Britain's High Court enforcement officers? They occupy a role unlike any other in the system. High Court enforcement officers are civilians, yet they act with powers granted directly by the High Court. While county court bailiffs are employees of HM courts and tribunal service, enforcing smaller debts with tighter limits on entry, HCEOs enforce high court writs, legal orders that can require them to enter residential or commercial property and seize goods or possessions where debts remain unpaid. Their civil powers of entry are based on the authority of a writ. These differ from police powers, but can in some situations permit forced entry for possession in ways that county court bailiffs cannot. That authority comes from their appointment. They are authorized under statute, approved by the senior master of the High Court, and their accountability is tied directly to judicial oversight. The crucial point is that they act as officers of the court itself, not as employees of a creditor. A company or individual may apply for their help, but once appointed to a case, the officer's duty is to execute the writ precisely as ordered, not to bend procedure for a client's request. This independence is part of why their position exists, to ensure the enforcement system retains judicial oversight in practice, not just in principle. The public often conflates them with bailiffs, but the differences are significant. A county court bailiff's work is usually confined to limited value debts and constrained entry rights, requiring cooperation from occupants in many circumstances. HCEOs, by contrast, are expected to carry out writs of possession and control over goods on behalf of the High Court, and their powers allow entry at times and in ways bailiffs cannot. The effect on the doorstep can be sharp. Someone who expects a delay or negotiation may instead find officers who can lawfully take control of assets then and there. This distinction explains why solicitors and debt recovery agencies so often escalate matters to the High Court when progress elsewhere stalls. Numbers illustrate just how significant that channel has become. In 2023, High Court Enforcement Officers Association figures show there were 146,965 new writs issued. Those writs represent enforcement on debts that had already passed through the courts and survived challenge. Collectively, members of the association in recent years have secured hundreds of millions of pounds in judgment debt on behalf of creditors. Ministry of Justice reporting alongside these figures confirms a rise in claims and enforcement activity after the pandemic years, with creditors increasingly choosing high court options to secure results. For officers, these are not just numbers on a page, but instructions they must turn into action at doors, workplaces, and properties across England and Wales. The authority written into a high court writ carries weight, but so too does the risk of facing resistance in person. Officers execute orders mostly alone or in very small teams, without the protective gear or numbers usually associated with police. Their open reliance is on the legitimacy of the documents they carry, but in volatile moments that legal authority must be asserted across a tense threshold. When resistance escalates or when safety becomes uncertain, they can request police support, but routine enforcement often unfolds without that presence. The danger is real. Threats of violence, attempts to barricade goods, or calculated obstruction are familiar parts of the job. Many officers describe the role as a blend of persuasion and procedure. They cannot step over the exact limits of a writ. Every act must withstand later scrutiny, but neither can they walk away leaving the order unenforced. A large part of their work is numerical negotiation, securing partial payment quickly, agreeing to short deadlines for cooperation, or allowing a debtor's solicitor to transfer funds during the visit. Other times, they must act decisively, calling in locksmiths to gain access or arranging transport for seized goods. Throughout, careful records are kept. Body-worn cameras, detailed notes, and receipts for seized items all form part of the accountability that balances their broad authority. The role's tension lies in that balance, total authority within narrow lines. The officer is highly constrained by what the writ permits, yet within that framework their actions cannot be delayed by emotion or sympathy. For a landlord or business waiting months after winning a case, the arrival of an enforcement officer often marks the first real consequence for the other side. Property is returned, goods are removed, and long-standing invoices are finally answered in some material form. For those on the receiving end, it is the cutoff point of the entire civil process. leaving few opportunities for further appeal or delay. The environments where this happens have changed. While residential doors remain part of the work, high-value commercial disputes now shape much of the caseload. Industrial units, retail stores, and office premises are frequent sites of repossession. These are spaces where officers may find entire groups of employees or tenants resisting, rather than a single householder. The scale of confrontation and the money at stake has grown with economic shifts following the pandemic. Companies closing, debts compounding, and disputes between landlords and commercial tenants all now feed into the stream of writs reaching HCEOs. The cost structure makes that stream self-reinforcing. Creditors pay an initial fee to instruct enforcement officers, but if the writ succeeds, that cost passes to the debtor along with enforcement charges. For debtors, that means a financial problem they already struggle with grows the moment enforcement begins. Every hour that officers spend on-site can escalate liability further. This adds pressure for quick resolution but also feeds resentment, which in turn shapes the resistance officers encounter. Even with that resentment, professionals in the sector emphasize the necessity of the role. Without enforcement, a civil judgment is only words on a document. The court process ends in a decision, but the order has little value until someone is empowered to act on it. HCEOs are the link between a ruling made in the high court and its tangible consequences in the real world. That link is why their work attracts scrutiny and criticism, while also being considered indispensable to a functioning system of civil justice. What is usually visible are the dramatic moments: locks being changed, belongings carried out, or businesses shut down. Less visible is the prolonged path of disputes, contract breaches, and court hearings that precede enforcement. But it is at the doorsteps, reception areas, or storage units where all that procedure turns into a physical reality. When an officer arrives with writ in hand, the months of paperwork culminate in action. Understanding these officers means recognizing their role at both scales: statistics charting hundreds of thousands of writs on one hand, and the quiet insistence of a knock at the door on the other. Both are central to how civil justice works in Britain today, and it is at that exact threshold where the real journey begins. The point where a court order shifts from paper into a life-changing event for the people on either side of the door. From paper to action, how a court order becomes an eviction. An eviction is not triggered by a locksmith at the door or an officer at the gate. It begins much earlier, often with something that seems minor at the time: an unpaid invoice, a missed rent payment, or a defaulted loan. At first, the issue remains between two parties. One expects payment, the other resists or is unable to meet their obligation. But once a creditor chooses to pursue a claim, the dispute is drawn into a formal process. What began as a private disagreement enters the structure of civil law, where documents, hearings, and rulings gradually build toward a potential outcome that reaches far beyond conversation. The usual first stage is the county court. A creditor files a claim outlining the debt and its basis. The debtor then has an opportunity to defend, submit evidence, or dispute what is owed. In some cases, there is no reply at all. If the defense fails or remains absent, the court issues a judgment confirming that the debt is legally due. To someone unfamiliar with the system, that judgment might appear to be the conclusion, a stamped order with a deadline for payment, carrying the formal seal of authority. Yet for many creditors, it is far from the end. A judgment in itself does not guarantee repayment, and months can pass without the debtor fulfilling the obligation. At this point, the process can escalate. If the debt is above a certain threshold and remains unpaid, the creditor may apply to transfer enforcement to the High Court. This is not automatic but conditional. Certain criteria must be satisfied before the request is approved. The order at the center of this step is a writ of control. Once granted, it directs a High Court enforcement officer to recover what the debtor owes by either securing payment or seizing goods of equivalent value. What to the court may appear as a simple line of instruction, take control of the goods of the debtor, is the moment when the case shifts into enforcement. A writ is not a general license. It is a court-authorized order with precise instructions, and officers must follow its wording exactly. They cannot go beyond what the writ specifies. If the order covers repossession, that is what they must achieve. If it authorizes the seizure of goods, they must act within the limits of what is listed or legally eligible. Their authority lies in restraint as much as action, ensuring that every step they take can be justified later in court. Once sealed, however, that formal document initiates consequences that are physically felt. Formerly abstract court paperwork soon directs locksmiths to change locks, officers to catalog goods, and vans to wait outside properties. Sums that appear in typed lines on legal papers turn into the removal of stock from warehouses or vehicles from driveways. For officers, this progression is routine, but for debtors, it can feel abrupt. The words they once held in hand are now embodied in the people at their door. Traditionally, the move from judgment to writ could take weeks or even months, slowed by forms completing their journey through different offices. Recent reforms and digitalization have accelerated parts of this sequence. Electronic filing and case processing now allow creditors to initiate enforcement far more quickly than in the era of paper-only procedures. For creditors, that means the gap between gaining judgment and applying for enforcement has narrowed. For debtors, it means there is often less time to arrange repayment before officers become involved. This speed changes the dynamic. Debtors who once relied on weeks of breathing room now find the window for negotiation exceptionally short. Payment plans discussed after judgment must be proposed swiftly or risk being overtaken by enforcement action. Warning letters may still arrive, but in some cases the process is already moving forward in parallel, catching those unfamiliar with the pace of modern systems by surprise. The first time many grasp the seriousness of a court order is not when they open an envelope, but when they see officers on their property. Still, it is important to recognize that enforcement is never the first step. Officers do not act on suspicion, nor do they arrive without cause. Every case that reaches their hands has already moved through contracts, reminders, court claims, and legal rulings. Only when payment fails despite a confirmed judgment does the writ open the way for high court enforcement. What looks like sudden disruption is in fact the closure of a long series of opportunities. This layered process also highlights the gap between the calm procedures of the courtroom and the visible impact at the site of enforcement. In court, matters are discussed in structured hearings, judgments are recorded in measured language, and outcomes are added to case files. On the street, the same judgment might mean an office emptied of furniture, a shop emptied of stock, or a family instructed to leave their home. The legal and the lived moment come together through enforcement. For officers on the ground, clarity of purpose helps steady what can otherwise be volatile encounters. They act according to what the writ sets out: to repossess, to take control of assets, or to restore property to its rightful owner. They keep detailed records, provide receipts for seized items, and use body-worn cameras to maintain accountability. To the individuals facing enforcement, these measures may feel secondary to the impact itself, yet they form part of the checks that ensure enforcement does not stray outside the authority of the court. Consider the perspective of neighbors watching from across the street. What appears to be an altered lock or a sudden eviction has actually developed through months of legal exchanges. The debtor may have challenged the claim or may have chosen not to engage at all, but at each stage chances existed to halt the process. By the time a high court enforcement officer presents a writ at a door, the journey has been mapped carefully by documents and decisions along the way. The system as it operates now is shaped by two contrasting qualities. It is structured and predictable for those who understand it, yet it can seem abrupt and unforgiving to those caught unprepared. For creditors, reform and digitalization make justice feel more efficient. For debtors, the compressed timetable can mean little warning before decisive action. This contradiction defines much of the enforcement landscape today, with its balance between fairness to both sides and the reality of limited timeframes. By 2025, these structural patterns remain in place but are joined by new pressures that change the day-to-day reality of enforcement. The legal pathway from a missed payment to a sealed writ is well established, but the environment in which enforcement occurs has shifted. That wider environment now shapes what officers face, what creditors expect, and how debtors experience the process. It is the conditions around the system, not the basic mechanism itself, that make the current moment stand apart. What makes 2025 different? What makes enforcement in 2025 stand out are three developments reshaping how writs are executed and how creditors and debtors experience the system. Company insolvencies have become a dominant driver of repossession work. Digital assets, once difficult to approach in enforcement, are now formally recognized and increasingly targeted. And new legislation under development gives clearer routes for officers to obtain digital account data, expanding the scope of enforcement tools. Each of these changes has altered the daily reality of high court enforcement officers. First, corporate insolvency. Government measures during the pandemic delayed the visible impact of financial instability. When temporary reliefs expired in 2023 and 2024, the accumulated pressures left many firms exposed. Data from the Insolvency Service confirms this. In August 2025, there were 2,048 registered company insolvencies in England and Wales, marking continued strain across the commercial sector. For high court officers, these failures translate directly into work. Landlords seek repossession of units, warehouses, and offices at higher rates as tenants default. Ministry of Justice statistics show that county court eviction processes remain slow, with an average of 37.8 weeks from claim to repossession when relying on bailiffs. By contrast, landlords increasingly turn to the high court pathway to regain property more quickly. Thus, writs of possession now involve large commercial spaces as often as residential homes. This change alters the dynamic of enforcement. Officers may face groups of employees or contractors on site, larger security requirements, and public attention when entire firms are shut down. The disputes themselves also play out differently. Commercial tenants often resist eviction by citing negotiations with landlords or claiming operational hardship. Yet once a writ of possession is issued, enforcement proceeds. Officers describe situations where directors attempt to empty stock overnight or staff are left outside buildings still carrying their personal belongings. Around 1 in 3 possession writs now involves commercial premises rather than individual households, a marked change compared with pre-pandemic enforcement. For creditors, this means faster recovery of assets and property. For debtors, it often signals the end of trading and the collapse of business continuity. The second shift concerns digital assets. Until recently, these presented practical barriers for enforcement. Cryptocurrencies could be concealed behind encrypted wallets or moved instantly across borders. Enforcement officers historically focused on tangible goods, vehicles, stock, or funds in traditional accounts. But over recent years, case law has begun to shape digital wealth into enforceable property. English High Court rulings, including those in Deloya and Piruzade, have confirmed that crypto assets can be treated as property subject to injunctions. Alongside this, the proposed Digital Assets Bill has moved towards establishing a clear framework for recognizing such holdings in law. For enforcement, this recognition matters. It signals to officers and creditors that assets once thought unreachable now fall within their scope. As a result, training has adapted. By 2025, new enforcement staff undertake digital tracing instruction, guided by specialists who teach them how to recognize blockchain transfers, liaise with exchanges, and cooperate with forensic accountants. Disclosure orders can now require debtors to identify wallets or online financial accounts. Officers have also begun coordinating with cyber teams able to restrict balances when linked to enforcement proceedings. This is not a frictionless process. Industry reports note strong recoveries overall, but outcomes are inconsistent. Some digital assets can be liquidated quickly, while other wallets remain inaccessible behind advanced encryption. Officers acknowledge that their reach has grown but admit the technical hurdles still create gaps. Even so, the steady integration of digital tracing into routine enforcement reflects a major evolution from a system that once overlooked such assets entirely. Legislation adds a third dimension. Alongside these economic and technological changes, legal reform has provided a wider enforcement toolkit. Proposals arising from the Civil Justice Council and the tribunals, Courts and Enforcement Act 2007 have led to discussions about implementing powers for creditors to request financial information from government departments. Measures expected to develop in 2025, such as provisions in draft data access legislation, would give clearer authority for officers to seek details on email accounts, online payment services, and digital wallets. These powers are designed with safeguards, requiring court approval and proportionality, but they nonetheless broaden what can be compelled during enforcement. Parallel reforms in corporate law also streamline the process of tackling company debt, allowing writs to cover linked entities within business networks. Critics caution against overreach, warning that these steps could burden debtors already in distress. Supporters counter that more efficient data access prevents dishonesty and saves months of delay. For enforcement officers, the effect is an expanded range of responses that extend from physical locks and vehicles to online accounts and financial platforms. These three developments do not operate in isolation. A case in 2025 might involve all of them at once: a company rendered insolvent by debt, officers tasked with repossessing its premises, and orders requiring directors to disclose digital assets held through online platforms. The officer's role has widened from managing confrontation at the door to navigating IT systems, corporate structures, and complex disclosure requirements. Each step demands strict compliance with procedure, while working under pressure from creditors expecting swift action. For creditors, these conditions mean greater certainty that judgments can be enforced quickly even in complex cases. A landlord with substantial arrears can expedite repossession through the high court route. A supplier owed significant sums can pursue not just the visible stock, but also electronic payment accounts. And with legislative backing, applications can compel access to information far beyond what was once possible. For debtors, the effect is the opposite: fewer opportunities to delay, fewer assets shielded from view, and tighter deadlines between judgment and enforcement. The pressure on them to comply with orders has intensified. The overall picture of enforcement in 2025 is, therefore, one of higher stakes. Company insolvencies push cases into larger public arenas, digital assets create technical and legal complexities, and expanding legislative powers shift the boundary between concealed and recoverable wealth. Officers themselves describe the job as changed, not only because of physical confrontation, but because the preparation, the paperwork, and the technical context demand far greater knowledge than before. They may stand in front of a debtor at their property, but in parallel they are engaged with online systems, disclosure orders, and industry specialists. By looking at these structural changes, we can see why enforcement work today requires more skill and caution than in earlier years. But recognizing the growth of officer power naturally raises a question. In this environment where writs are stronger and tools are broader, what prevents the imbalance from overwhelming those on the receiving end? That tension sets the stage for the next part of the story. Debtor rights and protections. Enforcement may appear absolute when seen from the outside. The arrival of an officer with a sealed high court writ carries a weight that feels non-negotiable, yet the law does not hand enforcement officers unlimited control. A framework of debtor rights and statutory safeguards ensures restrictions on what can be done, when it can be done, and how it must be carried out. These limits exist to prevent abuse, and while they do not erase the impact of enforcement, they preserve a basic sense of fairness in a process that can feel overwhelming. One of the most important safeguards concerns appeals. Even after a debt has been confirmed in court, a debtor can appeal the judgment or apply to vary its terms. Crucially, they may obtain a stay of enforcement if the court grants it. This is not automatic. Judges weigh the merits carefully and timeframes are usually short, but it ensures that enforcement is not immune to oversight. If a stay is granted, officers must suspend their work until the court decides otherwise. This mechanism allows mistakes, disproportionate orders, or significant new evidence to be reviewed, limiting the risk of wrongful enforcement progressing unchecked. The scope of what can be taken is also tightly defined. Officers are not free to remove every item they encounter. Exemptions are written into legislation. Essential household goods such as clothing, beds, cookers, and refrigerators cannot be seized. Tools of the trade, computers, or equipment necessary for employment are similarly protected within a monetary limit, allowing people to continue earning an income. The principle is straightforward. Enforcement should not strip away the essentials of living or make recovery from debt impossible. These limits mean that even in the most difficult cases, a debtor does not lose the basic necessities of home life or the means to work. Alongside exemptions, the law imposes specific responsibilities when vulnerability is identified. Officers are expected to assess circumstances at each visit. If someone is elderly, disabled, seriously ill, or facing acute hardship, they are not to be treated in the same way as others. Action may be delayed, additional time may be offered, or guidance may be sought from creditors before proceeding. Standards published by the Enforcement Conduct Board (ECB), introduced in 2022, give clear direction on handling vulnerability and complaints. Their research shows issues persist, breaches occur in a small but significant proportion of cases, but the framework sets expectations for behavior. Meanwhile, government consultations in 2025 consider making such oversight statutory, which would extend protections and strengthen accountability further. These ongoing reforms reflect an increasing recognition that enforcement powers reach their limit when set against society's most vulnerable individuals. Additional safeguards exist in the seizure process itself. Taking possession of goods under a writ does not transfer ownership immediately. Officers record and secure the items under a controlled goods agreement, giving debtors a final chance to pay before the property is sold. Installment plans are allowed under regulated terms, stopping officers from imposing excessive or arbitrary payments. This offers debtors one last opportunity to resolve the judgment voluntarily, making enforcement more than the blunt act of removal. Oversight also attaches to the conduct of officers. If they exceed the scope of a writ, seize exempt goods, or ignore vulnerability protections, debtors may lodge complaints. These can escalate through the creditor, the Enforcement Conduct Board, or regulators such as the Financial Ombudsman when financial firms are involved. In the most serious instances, judicial review may examine whether an officer acted outside the law. Each of these avenues creates additional checks. Enforcement is powerful, but it is not beyond challenge. By 2025, the area of protection that has grown most rapidly is digital data. With enforcement now extending into online accounts and crypto assets, concerns about privacy and misuse have intensified. The Data Use and Access Act 2025 clarified the boundaries. Officers can apply for disclosure orders to identify wallets or digital balances, but this is subject to strict audit and logging requirements, handled under guidance from the Information Commissioner's Office. Data gathered must be limited to what is directly relevant to the debt and cannot be retained beyond the lifespan of an order. These rules are still being rolled out and refined, but the principle is clear. Wider access to digital assets must be matched by strict safeguards to prevent intrusion into areas unrelated to the judgment. The law also prohibits broad or speculative searches for assets. officers must demonstrate relevance before gathering information. If a writ covers a specific debt, only accounts or holdings capable of satisfying that sum can be targeted. Attempts to gather unrelated data can be challenged and dismissed in court. The framework means digital enforcement cannot become an uncontrolled sweep of someone's private records. Instead, it is bound by proportionality and subject to oversight. Breaches can bring disciplinary action, legal costs, or invalidation of evidence. Despite these protections, criticism remains. Campaigners argue that many debtors face enforcement without legal advice, leaving them unaware of their rights to appeal, to claim exemptions, or to challenge misconduct. Others point out that while systems exist, they can be slow, and enforcement often moves faster than a complaint process. Supporters of enforcement counter that rights are present and documented, and officers are trained to follow them. The debate highlights the gap between protections on paper and protections in practice. In day-to-day encounters, these safeguards shape reality. A household expecting the loss of all valuables may find officers explaining which goods are off-limits. A debtor convinced there is no chance to pay may hear about installment options or controlled goods agreements. And when challenged, officers often point to the regulations themselves, lists of exempt items, formal vulnerability procedures, and the system of oversight as proof that their authority operates within real limits. Officers carry significant powers, but not undefined ones. The picture in 2025 is therefore one of balance. Enforcement powers have grown in scope, extending into commercial repossessions and digital assets, yet alongside that expansion, the legal restraints have deepened. Appeals, exemptions, vulnerability protocols, data protections all operate as procedural breaks. They are far from cosmetic. Each one shapes the boundaries of what enforcement can look like in practice. This ensures that while judgment debts are pursued decisively, the process does not devolve into the unchecked exercise of force. These protections, however, exist in the background. On the ground, the first impression of enforcement remains the sharp sound of a knock, the sight of officers at the door, and the sudden reality of action. It is at that moment, in real time, that the balance between authority and restraint is tested most clearly. On the front line, officers in action. It is in daily encounters that enforcement becomes most visible, and it is here that high court enforcement officers are most exposed. Their work is not only about paperwork and procedure, but about walking into real places with real people who may not want them there. Each year, thousands of high court writs are issued in England and Wales, and it is the officers on the front line who carry them from the page to the ground. A residential eviction often begins while the street is still quiet. The officer approaches with the writ in hand, the locksmith close by. The tenant, perhaps already aware or perhaps caught off guard, answers to be told that possession must be handed back. Some respond with pleas for time, asking for a few more days to find somewhere else or just enough hours to move belongings. Others are angry, protesting that they had not been warned, even though the legal process has run its course. For the officer, it is a careful balance. On the one hand, they have limited room to negotiate. The writ requires possession to be regained. On the other, the law does allow for some flexibility. A controlled goods agreement, for instance, lets payment be deferred briefly in exchange for a signed commitment and the listing of attached goods. In most cases, the locksmith works steadily in the background, and within that morning the property shifts back into the creditor's control. It feels sudden for those inside, but for the officer it is the predictable outcome of months of recorded proceedings. Commercial repossession is different in scale. Instead of household belongings, it is warehouses, offices, or industrial units that stand at the center. At one site, rows of trucks and shuttered doors made the scene look calm enough from outside, but waiting behind were dozens of employees wondering why they could not return to work. The officers arrived with the writ, changed the locks, and announced that the landlord was once again in possession of the property. The reaction from staff was immediate: questions, frustration, and sometimes anger that their company had collapsed without notice. Officers knew the risks of escalation. If hostility grew, they could call the police. Support was only a phone call away, but until that point they worked calmly, documenting everything. The writ allowed them to act, but restraint was what kept resistance from turning into full confrontation. In recovering company debts, the setting can be less physical but equally tense. Officers sometimes sit across boardroom tables from directors confronted with final demands for payment. Negotiation is almost always attempted. Offers of partial settlement, claims that money will arrive by the end of the week, or explanations that assets are tied up. The officer listens, weighs what is said, but remembers the fundamental fact that a writ is not a request, it is a command. Controlled goods agreements may again be used, allowing debtors a narrow period to pay before goods are seized, but the limits are clear. Once delays begin to look evasive, enforcement proceeds. In 2025, these face-to-face negotiations are increasingly joined by a new front: digital assets. Officers now bring with them not only orders for possession but also disclosure notices covering cryptocurrency and online accounts. Debtors may claim that wallet keys have been lost, that funds are overseas, or that exchanges cannot comply. The officer must judge whether these statements are genuine obstacles or deliberate attempts to block enforcement. In some cases, success comes quickly: funds identified, accounts frozen, payment made. In others, despite the legal power of the writ, the money remains untouchable, protected by encryption or hidden across platforms. Officers record the attempts carefully because in the world of digital enforcement, detail becomes the measure of accountability. One officer, recalling his time on a high-profile eviction, described being shouted at, threatened, and even having liquids thrown at him. It is not unusual. These confrontations, whether outside flats or across warehouses, are part of the routine. Officers know that while they often operate without immediate police presence, any sign of danger can and does bring uniformed support onto the site. They aim to project calm authority, knowing a heavy hand risks legal challenge later, but they also remain alert to personal risk in an unpredictable environment. Despite the differences between homes, offices, and encrypted accounts, a common thread runs through every enforcement action. The work is not carried out in silence. It is negotiated in conversations, challenges, and resistance. Officers explain the writ, spell out any possible agreements, and then if payment or cooperation does not come, act exactly as directed. When belongings are removed, when buildings are returned, when accounts are frozen, it is not by choice but by instruction. What varies is the level of resistance and the way it is managed. Negotiation is the space where humanity enters. Officers listen to the father asking for a few more hours to move furniture, the manager requesting time to let staff leave safely, or the director pleading for days to arrange a transfer. Sometimes grace is granted, sometimes not. What never changes is that a writ has an endpoint. It must be carried out. The measured calm of the officer, documenting everything, ensures that however the confrontation unfolds, it remains within the structure of legality. For the public, enforcement is often remembered in images. Locks changed under gray skies, furniture carried across the pavement, shutters pulled down on an office block, or the quiet exchange of papers requiring disclosure of digital accounts. These images tell the human story of enforcement, but the officer's role is more clinical. Their task is always to hold the line between authority and restraint, between the court's command and the chaos of personal loss. What this means in practice is that enforcement is both inevitable and costly in more ways than one. Every time an officer knocks on a door or files a notice to a debtor's solicitor, the confrontation brings financial consequences that stretch beyond the judgment itself. Next, we'll look at the real costs these confrontations add to an already painful debt. The cost of enforcement. When enforcement moves from paper into action, it also carries a price that goes beyond the original debt. The way the fee regime is structured in England and Wales means that the debtor is usually responsible not only for repayment, but also for the cost of enforcement itself. This design shifts the economic burden almost entirely onto the person who lost in court, ensuring that creditors recover what is owed without being left to subsidize the process. By 2025, the framework of charges is detailed, regulated, and often decisive in shaping how people respond when faced with enforcement. At the earliest stage, once a high court writ is lodged, a compliance fee is automatically added. Current regulations set this at £75, though it is worth noting that fees are periodically reviewed and may change. At this stage, the debt can be cleared with that relatively modest extra charge, making early cooperation the cheapest outcome by far. For many debtors, however, disbelief, denial, or lack of funds prevents settlement here, and that is when the scale of costs grows. The first direct visit from an enforcement officer moves a case into what is called the enforcement stage. This carries a much larger fixed fee, currently £235, plus a variable addition of 7.5% on any balance above £1,500. In straightforward terms, a debt of several £1,000s quickly increases by hundreds the moment resistance leads to a doorstep attendance. For a £5,000 debt, the enforcement fee can push the liability to more than £5,500 once percentages are factored in. These figures are not discretionary. They are set by the Taking Control of Goods fees, Regulations 2014, and remain in place unless formally revised by government. If property must actually be removed or sold, the sale stage is triggered and more charges apply. A further fixed fee of £110 is added, along with another 7.5% on sums over £1,500. Removal costs, storage, auction commissions, locksmiths, and security services are recoverable too. This means a case that progresses all the way from non-payment, through attendance, to forced sale of goods can see hundreds or even several £1,000s added on top of the original judgment. It is common for totals to rise far above the number first stated on a county court order. For debtors, the realization often comes too late that every stage of resistance compounds the cost. In practice, this sliding scale makes cooperation at compliance stage the least damaging option available. Refusal to pay or obstructing access rarely avoids enforcement, it just drives fees higher. Officers often emphasize this when talking to debtors on the doorstep. Engaging early can mean walking away with only the compliance fee, while failure to cooperate guarantees costs that grow quickly. Data published through the enforcement sector indicates that the average High Court enforcement case in England and Wales adds roughly £800 in extra fees to the judgment before reaching resolution. For larger commercial debts, proportional charges mean that liabilities can escalate by several £1,000s. The economics are designed deliberately this way. Government sets the fee structure not only to fund the system, but also to incentivize resolution without escalation. Enforcement officers are not salaried by the state in the way county court bailiffs are. Their agencies sustain themselves through fees added to cases. This model means creditors usually pay little upfront beyond the writ application, often less than £100. Those initial costs are reclaimable, which leaves minimal risk on the creditor's side. That incentive explains why escalation to high court enforcement is common once a county court judgment goes unpaid. It is a pathway that creditors know will almost always be funded by the debtor, not themselves. From the perspective of the debtor, the costs extend further than formal fees alone. Goods seized and sold at auction rarely achieve their market value. Vehicles, machinery, stock, or household items are typically sold quickly through auction houses at wholesale levels. A car worth £15,000 in private sale might fetch £10,000 when sold under enforcement. And from that reduced figure, both the debt and additional fees must first be satisfied. The debtor not only loses valuable property, but also loses at a discount, with little or no surplus left once enforcement costs are cleared. For companies, the implications are larger in scale. Repossession of warehouses or offices often brings locksmith bills, hired security, and transport for equipment, all of which are charged back to the debt. Directors who think resisting enforcement buys time often discover that every hour of delay adds to the bottom line of the company's final liability. Even when a business is already sliding into insolvency, these charges follow through, appearing in the tally of liabilities against which insolvency practitioners must reckon. Staff who see locks being changed may not realize that each imposed cost is falling into their employer's growing debt burden. The regime is not without critics. Some campaign groups argue that fees can devastate vulnerable households, and earlier parliamentary committees have questioned whether the current levels are set too high relative to inflation and the cost of living. There is also debate over whether an independent regulator should have powers to review fees rather than leaving them frozen for years. On the other side, the enforcement sector argues that fees have not been updated since 2014 to reflect inflation or the growing cost of service, warning that the sector risks being unsustainable if charges are kept artificially low. In 2025, government consultations continue to ask whether a statutory regulator with access to sector data should review the long-term balance. For now, though, the charges are fixed and enforceable, and debtors feel their full weight. The system does attempt to shape behavior. Resolving a debt as soon as the compliance letter arrives is framed as the lowest cost path. Allowing a controlled goods agreement during an officer's visit can prevent still higher expenses. By contrast, obstruction, delay, or deception nearly always ensures rising costs. From locksmiths and storage yards to auctioneers and digital tracing specialists, every service feeds charges back into the total bill carried by the debtor. Resistance often feels like standing ground, but in financial terms it is self-defeating. Even when enforcement fails in its immediate purpose, if assets are inadequate or funds cannot be secured, the costs do not disappear for the debtor. Interest continues, the record of non-payment further damages credit ratings, and alternative enforcement methods such as charging orders or bankruptcy petitions are still available to creditors. In practice, very few people find themselves better off for resisting. Most discover that delay has left them with increased fees and fewer options. This financial dimension explains much about how enforcement unfolds on the ground. Creditors know they are operating with low risk, officers execute writs knowing their pay is built into recoverable charges, and debtors encounter costs that rise in proportion to their resistance. The design is deliberate. It sustains the enforcement industry without direct state subsidy, it rewards compliance, and it penalizes delay. Whether one sees this as harsh or necessary depends on perspective, but its effects are felt every day in homes and businesses across England and Wales. What is less obvious in this financial structure is the human dimension that underlies it. Debtors do not only measure costs in pounds and fees, they experience fear, shame, and a tightening of pressure as liabilities grow. Officers themselves, while trained to stay impartial, are the ones who face borrowers, anger, despair, or desperation as fees multiply. Behind every rising balance sheet lie personal struggles, confrontations, and stresses that shape the reality of enforcement in ways numbers alone cannot describe. Psychological impact, enforcers and the enforced. The authority of enforcement is visible in action, but its hidden weight lies in how it affects the people involved. Enforcement is not only about court orders being carried out, it is about the psychological consequences for those who enforce them and those who live through them. Here, both officer and debtor step into a situation that is not purely legal, but deeply emotional. For enforcement officers, exposure to stress is constant. Aggression is not an occasional problem, it is a routine expectation of the job. Officers describe being shouted at, insulted, threatened, and sometimes physically targeted. One senior officer has spoken of being spat on and even having liquids thrown in his face. Remaining calm in the face of such behavior is part of the professional role, but repetition takes its toll. Behind the appearance of composure, every confrontation adds to a store of stress that cannot easily be set aside at the end of a shift. The role demands not just physical resilience, but emotional restraint sustained across dozens of encounters each week. The impartiality officers are asked to show is itself a source of emotional strain. They carry the authority of the High Court, yet they look directly into the lives of people who often break down in front of them. Tenants in tears as furniture is removed, families insisting they have nowhere left to turn, directors begging for time as staff look on. Officers must listen without cruelty, but they must still act. This balancing act, acknowledging distress while enforcing a judgment, creates an emotional burden that is carried silently and accumulates over years. One officer described the conflicted feeling of satisfaction in fulfilling a landlord's writ of possession, immediately shadowed by the recognition that a family had just lost the place they called home. These dual feelings of professional pride and private regret are never far apart. Debtors face the encounter from the opposite side. For them, enforcement is not a professional challenge but a personal crisis. Fear is the first reaction, fear of losing a home, of strangers entering private space, and of the public visibility of possessions being taken away. Humiliation often follows, particularly during evictions conducted in full view of relatives, neighbors, or employees. Already under financial pressure, debtors often describe enforcement visits as the tipping point that pushed stress into despair. Research makes clear how strongly debt and mental health are connected. The Royal College of Psychiatrists estimates that 1 in 2 adults with problem debts also has a mental health condition. The Money and Mental Health Policy Institute has shown that around 10% of people with mental health problems are behind on council tax bills, compared with only 4% of those without such conditions. Nearly 3/4 of people in council tax debt who received a bailiff or enforcement visit reported having a mental health problem. These figures show that when the knock on the door comes, it disproportionately falls on those already struggling with psychological health, compounding existing vulnerabilities. Officers are aware of this reality, and it makes their own position more complicated. They must enforce the writ, but they cannot ignore what they see. The daily work of repossession reinforces a constant tension. Each task successfully completed for a creditor may mean deep disruption for a debtor. It is this gap between professional duty and personal empathy that defines much of the inner strain officers carry. The sector has begun to acknowledge this. By 2025, officer training is no longer confined to legal procedure and methods of seizure. Resilience training and stress management have become part of the curriculum for recruits and established personnel alike. Employers have introduced structured debriefs after difficult cases and set up peer support programs within enforcement companies. Oversight has also grown. The Enforcement Conduct Board, created in 2022, monitors officer behavior, investigates complaints, and promotes standards that emphasize both professionalism and recognition of vulnerability. Current government consultations are considering whether to put such oversight on a statutory footing, reflecting a broader recognition that mental health support must be built into enforcement as a profession. For the officers themselves, the greatest challenge is rarely found in physical altercations but in the quiet aftermath. Sudden hostility can be endured in the moment, especially when adrenaline is high, but the memory of faces and situations stays with officers long after they leave a site. Those in the role talk about making 10 or more enforcement calls a day. Each visit brings its own wave of emotions from the debtor: pleas, anger, resignation, and absorbing this cumulative impact is one of the hardest aspects of the job. Projecting authority and neutrality is expected, but it comes at the cost of private stress. Technology has added new layers of pressure. Officers must now engage in forms of enforcement that move beyond visible goods. Disclosure orders covering cryptocurrency or online accounts involve cooperation with cyber specialists, exchanges, and digital tracing experts. Resistance here is less about shouting at the door and more about technical arguments over access and encryption. For officers, the stress comes from navigating areas in which expertise is evolving, but expectations from creditors remain high. They must manage both the legal procedure and the emotions surrounding it. But in digital enforcement, the confrontation is less visible and potentially even more exhausting to resolve. Debtors, meanwhile, feel new kinds of anxiety from the digital shift. Having vehicles taken or offices cleared is painful but easy to imagine. Learning that digital wallets or trading accounts can be frozen transforms that fear into something different. The belief that no area of life is safe from enforcement. For some, this worsens existing mental health problems, leaving them feeling as if even private, intangible assets are vulnerable. This psychological pressure feeds into the wider cycle of strain created by debt, further entrenching the link between financial and mental health struggles. These psychological realities mean enforcement is never just about paperwork or possessions. Every writ enacted has two outcomes: the visible material one, a repossession, a seized item, a frozen account, and the invisible emotional one carried forward in memory and feeling by both sides. Officers bear the burden of hostility and guilt. Debtors bear the weight of humiliation, fear, and uncertainty about the future. These are the unseen consequences of civil justice delivered through enforcement. While progress has been made with resilience, training, and oversight, the fundamental challenge remains. Legal authority can mandate repayment, enforce possession, and compel cooperation. What it cannot do is insulate the people involved from the emotional costs those actions create. Officers speak of developing coping strategies, but coping is not the same as escaping. Debtors may eventually resolve their financial liability, but the psychological scars can last far longer. This is why in 2025, enforcement discussions increasingly recognize mental health as central to the process. Court orders reflect numbers, dates, and property law, but on the ground they translate into lived disruption and deep-seated strain. The growing focus on protections from regulators and support for officers shows that enforcement is now understood not only as a legal duty, but also as an arena where human resilience is tested at every turn. Yet even as the emotional cost is acknowledged, a new front in enforcement introduces further challenges. Officers are asked to chase value that cannot be touched, assets that do not sit in warehouses or driveways but exist instead in digital accounts and encrypted codes. How enforcement adapts to this shift is already shaping the future, and it is here that the landscape begins to change again. Digital fortresses chasing crypto and online assets. How do you seize assets that cannot be touched? A car can be removed or machinery locked and sold. But in 2025, a growing share of wealth sits in coded strings of data rather than driveways or warehouses. Cryptocurrency and online accounts have become central to enforcement cases, and they present obstacles no locksmith can overcome. Officers once focused on doors and locks now arrive with disclosure orders covering digital platforms. The physical knock still matters, but increasingly the threshold they must cross is virtual. The difficulty arises from the very design of crypto. Unlike bank deposits secured through regulated institutions, digital tokens exist on decentralized ledgers distributed across a global network. A Bitcoin is not a coin but a string of code controlled by a private key. Without that key, the asset cannot be moved, regardless of what the court or officer demands. For enforcement, the challenge is stark. Even if there is firm evidence a debtor holds substantial assets, recovery depends on either their cooperation or on the courts granting orders that reach into the systems that protect those holdings. Recent case law in England has begun to treat cryptocurrency as a form of property, while legislative steps are reinforcing that direction. The Digital Assets Bill, expected to progress in 2025, will make explicit that such holdings are to be recognized as property under statute. This gives courts clearer grounds to treat digital tokens in the same category as other enforceable assets. High court writs can now specifically reference wallets or accounts, making them targets of enforcement in principle, not just physical property. This clarification shrinks the gray area that once let digital wealth remain beyond reach. The legal framework is also shifting through other channels. The Crime and Policing Bill 2025 contains provisions designed for policing but relevant to enforcement. Authorized officers under senior approval and subject to codes of practice may obtain access to remotely stored electronic data. These powers include the ability to retrieve information otherwise shielded by device security or account authentication. For enforcement, the significance is clear. It means that, under careful oversight, access to critical information held in online accounts may be compelled where it was once considered untouchable. This is not automatic or unrestricted. Every step requires legal authority, but the direction of the law is towards closing gaps that favor debtors. Operationally, enforcement officers no longer act alone when it comes to digital assets. They work in partnership with cybercrime units, regulators, and forensic analysts. Exchanges, too, have become vital intermediaries. Where someone attempts to conceal assets on a trading platform, officers can secure disclosure and freezing orders that force cooperation. Specialist firms use blockchain analysis to trace the movement of funds across thousands of transactions. Each token leaves a visible record, and while tracing remains complex, the tools now exist to connect wallets to individuals with much higher confidence than a few years ago. Practical results support the value of these powers. In 2024, a company director shifted profits into a series of wallets to escape repayment. Forensic tracing demonstrated the link, and under a writ, the director was required to disclose keys. Non-compliance carried the threat of contempt, and eventually access was surrendered. Hundreds of thousands of pounds worth of tokens were recovered. Cases like this reassure creditors that applying to the High Court can indeed turn digital concealment into recoverable funds. Success, however, is far from guaranteed. Some wallets remain sealed because keys are claimed to be lost or destroyed. Officers cannot break strong encryption, and courts cannot create access where no data is provided. In such circumstances, the assets remain visible on the blockchain but practically unreachable. The court may still impose sanctions, fines, costs, even imprisonment for contempt, but the coins themselves sit inert, untouchable behind private coding. These outcomes underline the limits of legal authority when confronted by technical barriers. The consequences of inaccessible wallets are heavy. Creditors see wealth but cannot realize it. Officers feel frustration where a writ authorizes action but produces no result. For the debtor, the pressure remains severe. Sanctions may be applied regardless of whether the story of lost passwords is genuine or not. Enforcement in these cases becomes less about physical seizure and more about continual legal pressure to induce cooperation. On the ground, enforcement visits now combine the familiar and the new. Officers may still catalog furniture or vehicles, but they also ask pointed questions about cryptocurrency accounts and online balances. Disclosure notices compel answers, turning ordinary conversations into legal obligations. A search may involve scanning paperwork for recovery phrases or identifying hardware wallets disguised as ordinary devices. A USB stick on a desk may represent more value than all the goods on the property combined. That search changes the tone of encounters. When furniture is removed, at least the actions are visible. When asked to hand over a recovery phrase, debtors often protest that their privacy is being invaded. Some argue that wallets belong to relatives or pretend nothing exists. Officers are used to such claims. The risks of non-disclosure now make them less persuasive. With contempt powers looming, many debtors conclude that cooperation is safer than resistance. The sums at stake explain why such disputes escalate. A single wallet can contain millions, dwarfing the market value of physical property. Securing or failing to secure those sums can determine whether a creditor recovers almost everything or nothing at all. Devices such as laptops and phones, once peripheral to repossessions, take center stage. Officers handle them as carefully as physical goods, documenting their seizure and securing authorization for access under legal codes. The rise of digital enforcement also brings new debates. Oversight rules require that only accounts relevant to the case be examined. Officers cannot indiscriminately trawl through digital lives. Every request must be justified, every extraction logged, and audit systems retain records of what was accessed and why. Advocates argue this ensures fairness and accountability. Critics maintain that even targeted access feels invasive to people already under financial distress. This tension mirrors the broader challenge of adapting civil enforcement to an era where assets flow invisibly across borders. What emerges is a profession stretched into new terrain. Enforcement officers now work not only with locksmiths but also with data specialists. Their writs cross thresholds both physical and digital, requiring them to explain technical orders as well as physical repossessions. For some officers, this adds to professional strain. They must represent authority in areas traditionally far from legal practice. For creditors, the shift signals reassurance that debts cannot simply vanish into encrypted code. Still, barriers remain. Technology enables recovery but also makes concealment harder to fully defeat. Officers and creditors now accept that while digital possessions are no longer legally untouchable, they are not always practically recoverable. Courts can compel, exchanges can cooperate, forensic tools can trace, but absolute access cannot be guaranteed. In many cases, debt will eventually be satisfied. In others, the ledger of the blockchain will show wealth that remains beyond reach indefinitely. This uncertainty highlights the difficulty of extending civil enforcement into digital economies. Legal tools can adapt, operations can modernize, and cooperation with regulators can expand. Yet for officers and debtors, the encounter still strips back to a confrontation, law demanding access, privacy resisting it. The difference is that the confrontation no longer plays out only on the doorstep but across unseen networks. The growing attention to digital assets shows how enforcement has had to keep pace with financial change. Virtual property now carries equal weight to goods once stored in homes or offices, and officers must span both domains with equal authority. It has redefined the boundaries of debt recovery, drawing them into spaces that feel unfamiliar and contested. From here, the scope of enforcement widens again. Beyond households and digital wallets, entire companies stand at the edge of this system, with writs capable of shifting control of office towers and warehouses. The next arena brings not just individuals in debt, but corporations whose very premises can change hands under a high court order. Corporate debt and commercial takeovers. Corporate debt disputes in 2025 are reshaping the ground on which high court enforcement officers operate. When companies collapse under heavy liabilities, the writs that follow are often large in scale, securing warehouses, closing office blocks, or locking out staff on behalf of creditors. August 2025 alone saw 2,048 registered company insolvencies in England and Wales, many of them creditor-driven and linked to debts that directors could no longer service. Each insolvency becomes more than a line in an official report. For officers, it is the start of physical repossessions across commercial spaces where employees and customers once moved freely. Economic support rolled out during the pandemic delayed some of these impacts, but once subsidies expired and trading conditions shifted, many firms exposed underlying fragility. Post-pandemic adjustments combined with higher borrowing costs and unresolved structural weaknesses have continued to push businesses into insolvency. Enforcement officers now deal daily with the consequences. Commercial landlords reclaiming sites, suppliers chasing overdue accounts, and banks seeking recovery against companies that can no longer trade. For many enforcement professionals, this is now the dominant stream of cases, less about small household debts, more about large-scale repossessions that reshape local economies. The composition of recent insolvencies illustrates the point. In August 2025, the majority, around 1,600 cases, were creditors' voluntary liquidations where directors accepted that closure was inevitable. These scenarios frequently require rapid attendance by officers to prevent unauthorized removal of stock. In over 300 cases that same month, insolvency was compulsory, meaning that writs authorized officers to seize control of premises directly for the benefit of creditors. Staff could turn up for a day's work and instead encounter enforcement officers at the gates. Each category has its own procedures, but both thrust officers into public, high-stakes roles where the fall of a company is witnessed in real time. The practical demands are higher than in residential work. Securing commercial premises means organizing locksmiths to change multiple locks, arranging security to oversee large sites, and coordinating with removal teams to record high-value assets ranging from IT systems to industrial machinery. The process resembles an operational takeover as much as a repossession, an exercise in control of entire spaces rather than isolated items. Officers describe these operations as fast, visible, and sensitive, especially where employees are present and looking for answers the officers cannot provide. Public visibility is an unavoidable element. While a household eviction may pass with little notice, closing a retail chain or manufacturing plant is harder to disguise. Workers protest, journalists sometimes attend, and the event can spread across social media within hours. In those moments, enforcement is not quiet procedure but a highly public act. The officers themselves must continue applying the writ with precision, knowing that cameras or smartphones may record every move. Legal correctness and professional conduct are, in those settings, as important as securing the premises. Illustrations from 2025 show how scale alters the atmosphere. In Birmingham, officers attended the premises of a liquidated electronics distributor, securing a huge warehouse containing thousands of units of stock. A removal team cataloged and sealed goods under supervision while staff gathered outside. In another operation, a mid-sized retail chain defaulted on lease payments across several towns. Multiple writs coordinated on the same morning meant officers were deployed to repossess shops simultaneously, foiling attempts to shift stock between locations. These examples underline that when companies collapse, enforcement stretches beyond single sites and often requires coordinated action across multiple properties. For landlords and creditors, delay can prove costly. Assets risk being sold off informally, dispersed, or written down in value if enforcement lags. This is why high court enforcement officers are often instructed as soon as writs arrive. Their task is not just to enter but to take control quickly, reducing the scope for dissipation of assets. For company directors, that makes stalling difficult. Once insolvency is formalized and a writ issued, opportunities to negotiate are narrow. Larger changes in the regulatory environment also set the backdrop. Early in 2025, the Digital Markets, Competition and Consumers Act came into force, greatly expanding the powers of the Competition and Markets Authority. While the CMA's focus is on regulating markets and overseeing mergers, its reach influences commercial disputes more broadly. Large technology and digital sector firms designated with strategic market status must report acquisitions and comply with stricter rules. When these companies face financial distress or legal challenges, writs issued against them unfold within this wider net of regulatory oversight. For officers, it rarely changes their immediate task. They still secure premises or equipment, but it does create additional checks and coordination with regulators before enforcement can proceed smoothly. The difference in commercial work also lies in the human encounters. Residential enforcement typically involves one or two individuals making personal appeals. In corporate shutdowns, officers find themselves speaking to dozens of staff emerging from offices or factory floors, many learning the fate of their workplace only as officers arrive. Those officers cannot explain corporate insolvency law or director behavior. Their legal authority is limited to the writ itself. This creates tense moments where employees see them not as neutral executors, but as the embodiment of their employer's collapse. Managing crowd reactions calmly and safely is a core part of the professional discipline expected of experienced officers. Corporate enforcement also extends into areas tied to digital businesses. Companies trading online may not possess much physical stock, but still rely heavily on servers, routers, and on-site technical equipment. Officers do not seize intangible assets such as intellectual property directly, but they can and do secure the physical infrastructure that supports them: offices, server rooms, or lease spaces that hold hardware. The control of these entry points ensures creditors and insolvency practitioners can later marshal resources, even as specialist agencies handle the digital side. This division of responsibility, officers taking physical custody while regulators or courts deal with intangibles, defines how commercial enforcement adapts to a changing economy. The longer-term statistics emphasize continuity as much as change. On a rolling 12-month measure up to August 2025, 1 in every 190 active companies entered insolvency, equal to 52.6 per 10,000 enterprises. That is slightly lower than the year before, but still a historically high rate. For high court enforcement officers, this means a steady supply of writs to enforce, maintaining commercial cases as a consistent portion of their workload. From independent shops forced to close after lease defaults, to multi-site corporate entities with hundreds of staff, the stretch of enforcement covers a spectrum rarely seen in residential work. For the officers, the demands are heavier. They enter reception areas where staff are still at desks, unaware a winding-up order has already sealed their fate. They turn keys on factory floors mid-production, halting work instantly. They monitor staff as personal items are collected under supervision, all while handling the tensions and emotions of groups uncertain about their future. The principles of enforcement: execute the writ with accuracy, remain impartial, maintain documentation, remain the same. But the visibility and consequences of corporate enforcement are magnified many times beyond what occurs in domestic spheres. By 2025, the steady cycle of company failures has made corporate enforcement part of the daily landscape, a routine where court orders intersect directly with jobs, property, and commercial networks. Officers understand that in carrying out a single writ, they may alter the trajectory of a firm, a workforce, and an area's economy. Each action marks more than the transfer of physical keys. It represents the enforcement of commercial reality at scale. And just as writs against corporations reshape office blocks and industrial sites, a different challenge is gathering shape in parallel: the search for debtors who no longer maintain fixed workplaces. For enforcement officers, adjusting to this dispersal of people and property is becoming one of the most persistent tests of their role. Remote working, remote evictions. What happens when the debtor no longer has a fixed place of work? For high court enforcement officers in 2025, this is now a routine difficulty. The pattern of employment has shifted. More people work from home, use co-working desks, or earn money entirely through online platforms. The absence of a single, reliable workplace has changed both the practical and legal shape of enforcement, forcing officers to rethink approaches that once revolved around offices, shops, or warehouses. Remote and hybrid working patterns, now an established post-pandemic reality, mean debtors often use personal residences or virtual addresses where the lines between business and private life blur. For officers, this replaces the straightforward act of serving notices at company premises with more complex judgments. What counts as personal, what counts as business, and which goods can be lawfully seized without infringing protections. Just as regulators in sectors such as finance have adapted rules to reflect home-based work, enforcement has had no choice but to adapt its methods to this dispersed workforce. For gig workers and freelancers, the challenge intensifies. Many operate without formal payrolls or long-term contracts, receiving irregular payments across several digital platforms. When officers attend the debtor's registered address, they may find nothing resembling a traditional workplace, only everyday household equipment or laptops that serve both professional and family purposes. The boundary between exempt tools of the trade and seizable assets narrows, and every decision carries the risk of legal challenge. Enforcement here often relies less on physical seizure and more on digital tracing. The strategies supporting this work have become increasingly technical. Officers now follow online breadcrumbs, photos, tagged locations, platform payment histories, to confirm where debtors operate and which assets might exist. These lead searches into co-working hubs or residential settings, replacing predictable workplace visits with scattered investigations. Corporate registry filings and service addresses add extra pieces, though debtors may attempt to obscure operations through virtual offices or PO boxes. Enforcement companies have responded by refining address verification and working with postal services to confirm whether activity truly takes place where records suggest. On the ground, this translates into different types of encounters. Officers may arrive at a co-working center, speak with receptionists, and attempt to locate an individual who rents a desk among dozens of others. In other cases, they stand in suburban homes that function simultaneously as living spaces and registered business addresses. Deciding which property belongs to the debtor and which belongs to other household members requires both experience and caution. Removal of the wrong items risks liability. Hesitation risks an incomplete execution of the writ. Home offices add extra complexity. A single computer may store a family's personal photographs alongside the debtor's professional accounts. Taking it away fulfills the enforcement order but interferes with household life. The law's exemption for essential household goods and tools necessary for work both apply here, but applying them is rarely straightforward. Officers must weigh the specific wording of the writ against these protections, often under the pressure of debtors, protests, or claims of hardship. When debts are large, compromises become harder, yet officers still try to resolve cases through payment agreements before resorting to removal. Recognizing that traditional skills alone cannot meet these demands, enforcement agencies have invested in digital investigation training. Staff now learn to interpret online activity, cross-reference data, and use analytic software to build profiles before a visit takes place. Some firms employ specialist digital tracing units that pass intelligence to field officers preparing to enforce. Collaboration with cybercrime teams has increased where encrypted accounts or hidden wallets complicate recovery. The role of the enforcement officer is becoming as much about understanding digital landscapes as about managing face-to-face confrontation. For debtors, this shift often undermines expectations of safety. Many assume that home-based working hides them from view, but officers now rely on online financial records, gig platform payment histories, and corporate filings to prove income or locate assets. A freelancer compensated through an app may find those records subpoenaed, exposing the financial trail despite the absence of a workplace. Payment flows invisible to neighbors or colleagues are still accessible to the court, and officers have authority to follow them as far as orders permit. This development heightens concerns around privacy. Officers must still respect legal limits. Disclosure requests and digital evidence collection must be scoped to the debt in question and reviewed under existing data regulations. The law does not allow unchecked trawling through personal accounts even when suspicion is strong. Guidance from the Information Commissioner emphasizes oversight and proportionality. Yet for debtors, even limited disclosure can feel intrusive. Being compelled to reveal gig platform income or subscription histories strikes at the personal side of livelihoods that exist within private devices. Asset seizure itself reflects the new nature of work. Instead of machinery or stock taken from business sites, officers now focus on laptops, cameras, and specialist tools. These may represent the debtor's main assets of value. The challenge lies in distinguishing between what counts as essential for daily work and what extends beyond reasonable need. A single laptop may be protected, several high-end devices might not. Each judgment can be contested, so officers meticulously document decisions to withstand later review. Flexibility has become the operating principle. Officers expect debtors to be mobile, shifting between kitchen tables, shared offices, and virtual addresses. Enforcement relies on adjusting quickly, tracing value through databases and online records, and appearing wherever the writ requires, even in unconventional locations. The fixed landscapes of offices and factories have receded, replaced by a dispersed terrain where authority follows the flow of money rather than the footprint of buildings. This adaptation comes with wider implications. Digital evidence is now a foundation of process rather than a supplement. Trained staff spend time reviewing posts, payment records, and filings before enforcement actions. The findings form part of the file submitted to the court, giving creditors greater confidence even when workplaces no longer fit traditional categories. For officers, this preparation is essential to reduce wasted visits and strengthen the legitimacy of steps taken. The reliance on digital proof also reshapes the experience for debtors. For some, it appears that enforcement reaches into every part of their lives: home, online presence, financial platforms, leaving no separation between personal identity and professional activity. For others, it reinforces the weight of a court order, demonstrating that even mobility and virtual work do not negate obligations. Both perspectives highlight how enforcement continues to evolve with working culture and technology. For the enforcement sector, these changes carry practical demands: investment in training, new partnerships with regulators and investigators, and refined communication capable of working in a world where debtors are no longer tied to fixed locations. Trade commentary notes the growing importance of digital literacy among officers, suggesting that success in the coming years depends as much on data analysis as on face-to-face negotiation. By the middle of the decade, the message is clear: remote working may redefine employment and how businesses operate, but it does not dissolve debt or shield assets. High court enforcement officers, adjusting their methods, now pursue obligations across hybrid spaces where the distinction between personal and professional weakens. The writ remains the instrument of authority, reaching from conventional offices to private homes and digital platforms. And it is in this expanded setting, across both physical and virtual frontiers, that the true character of enforcement work in 2025 emerges. Officers applying powers grounded in tradition while navigating environments that would have been unimaginable a generation ago. High court enforcement officers now stand where centuries of legal authority collide with the realities of a digital and dispersed economy. Their writs still carry the same court seals that judges have issued for generations, but the scope of enforcement now stretches across online wallets, trading accounts, and corporate spaces as much as homes or warehouses. Between the 146,965 high court writs issued in 2023 and August 2025's 2,048 company insolvencies, the pattern is clear. Enforcement has firmly entered the digital and commercial age. They don't set policy, but their daily work shows how law meets life, and why reforms on digital assets, safeguards for vulnerability, and data rules matter now. If you want a deeper look at how crypto is being treated in court, comment below. We'll stick to the facts the next time.